Okay, hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again, and we are back with a new video on your legal affairs and some maxims for your CLAT and AILET in 2022 and 2023. So anyone who's watching this video, do make sure that you are hitting on the like, share, and subscribe button, and make sure that you don't forget to hit on the bell icon. Right? So as we all know that AILET is has changed its pattern, and also there are new kind of things that will be coming up in AILET, and the whole scenario for the exam has changed. But you need to be rest assured that your GK and your legal aptitude or other any subjects that you are studying will remain on the same lines, right? So you shouldn't forget the lines that you were preparing on. So AILET ke liye, please be rest assured that what you're preparing for CLAT will suffice for your AILET examination. Do make sure that you are not getting scared because of that pattern change. Okay, it is the same examination, just in a little new clothes, right? So just stay calm and stay focused on the examination, and just don't think that the pattern change will ruin everything that you've studied till now. Stay confident about your preparation and about yourself also, right? So if you are not a part of a Telegram channel, do make sure that you are subscribing to our Telegram channel also. Okay, so hi Anshita, I hope you are doing great. Okay, so the Cuber has asked me this legal and logical में अब सिर्फ पैरा है ना. देखिए Mr. The Cuber, I would say that there can be paragraphs also, and also you never know that the entire section can also be logical reasoning. But as they have said that there are legal principles involved in it, so you need to make sure that you are taking care of those legal principles also. Okay, so definitely there can be paragraphs, and there can be a little comprehension based logical reasoning also. So you need to make sure that you are preparing in every manner, right? जो मैं आपको बोल रहा हूँ कि जो क्लैट के लिए पढ़ रहे हैं आप, वो एलेट के लिए सफाइस करेगा. दैट मींस व्हाटएवर यू आर स्टडीइंग फॉर क्लैट will suffice for ALET. You don't need to change any pattern of your preparation for the examination particularly. Okay, so ALET के अंदर पहले स्टेट प्रिंसिपल फैक्ट बेस्ड क्वेश्चंस आते थे, वैसे भी आ सकते हैं अभी भी लॉजिकल रीजनिंग सेक्शन के अंदर जो कवर किया जा चुका है, right? Now coming to the first news for the day, that is that married daughters are entitled to compassionate appointments on death due to COVID. राइट, कंपैशनेट अपॉइंटमेंट मतलब किसी के जो एम्प्लॉय काम करते हुए जिसकी ऑन ड्यूटी डेथ हो गई है, सो उसकी मैरिड डॉटर को भी एक अपॉइंटमेंट दिया जा सकता है इफ द डेथ वाज ड्यू टू कोविड. राइट, दैट हैपेंड इन आंध्र प्रदेश हाई कोर्ट. दिस वाज जस्टिस नीलालाल जयासूर्या of Andhra Pradesh High Court, who held that the married daughter is also entitled to such compassionate appointments, and also her marital status will not be a bar to claim the welfare scheme based on the facts and the circumstances. Right? So they have stated clearly that there's no bar on that. You can definitely take the advantage of the compassionate employment, and also it doesn't depend if they are married or not. Right? And there was a writ that was filed by the petitioner, who was aggrieved by the proceedings in rejecting the case of the petitioner for the compassionate appointment as illegal, arbitrary, unjust to quash the same, and for consensual direction to the respondents to appoint the petitioner in any suitable post on the compassionate grounds. Right? So ऐसा हो रहा है, हुआ है और बोला गया है आंध्र प्रदेश हाई कोर्ट के द्वारा. And you can see the name of the justice was Justice Ninala Jayasurya. Right, so I hope everybody is clear. The Cuber, I hope आपके क्वेश्चन का आपको आंसर मिल चुका होगा आगे वीडियो में. Right, so do make sure that you are hitting on the like, share and subscribe button for us to answer more questions of yours. Now coming to the next news for the day, that is that the death. अब हम सब मेंटल हेल्थ के बारे में हमने बहुत ज्यादा बात करी है. ऑल द पीपल हैव बीन वेरी इन्वॉल्वड इन दिस कोविड टाइम्स. वी हैव रियलाइज्ड what is the value of mental health, what do you mean by anxiety, what do you mean by depression, what do you mean by loneliness. Everything has struck. Now people have started talking broadly about mental health as a part of the daily life, and earlier it was not considered to be a very big problem, but now it is considered to be a serious issue, and definitely something that is considered in an employee's well-being. Okay, so now there was a death that was caused by stress and strain due to employment. So the Bombay High Court has told the employer to compensate on such grounds. Now there was a case that was being filed in the Bombay High Court where recently they directed the employer to compensate the kin of a truck driver, observing that the stress and the strain caused due to his employment has ultimately led to his demise. And also, there was Justice N.J. Jamadar, who held that the deceased driver's heart attack could be termed as an accident arising out and in the course of his employment, as contemplated under the Section 3 of the Workmen's Compensation Act. Okay, so Bhavya asked me, is it necessary to watch this? Bhavya, nothing is necessary in this world to watch, right? It depends on you. And if you're preparing for law, then definitely it's necessary to watch. If not, then you can definitely choose to skip on the session. Not a problem for us, right? Now, the thing that was said was that the heart attack was caused under the course of employment and can be contemplated under Section 3 of the Workmen's Compensation Act, right? The act that is used to provide compensation to the laborers in the unit or any employee that is working in any scenario, right? So that is called the Workmen's Compensation Act. Now, what did the court say? And I quote and unquote again, that I am persuaded, okay, that's the judge here, to hold that in fact of the instant case, the death of the deceased can be said to have accelerated on the account of stress and strain associated with the long distance driving for almost 18 days in tiring circumstances. Any other view of the matter would defeat the beneficial object of the provisions contained in Section 3 of the Employees Compensation Act 1923. Right? So it is straight said by the judge कि ये सब जो हुआ है 18 days of tiring journey and circumstances has led to his death. So employer is definitely liable under Section 3 of the Employees Compensation Act, Workmen's Compensation Act, the same thing. Right? Chaliye, coming to the next news for the day, that is that the right to health and the provisions that are related to the medical treatment, right, reimbursements, ठीक है, जो भी provisions हैं जो medical treatment के reimbursement से हैं वो construct होने चाहिए liberally. अब इसका मतलब क्या है, ये क्या कहना चाह रहा है, मैं आपको बताता हूँ. ये सब चीजें आपको लॉ स्कूल में जाने से पहले अगर पता लग जाए तो उससे अच्छा क्या हो सकता है, right? So constructed liberally, this term comes from a subject called interpretation of statutes, right? That how is a statute interpreted? क्या वो उसका literal interpretation होना चाहिए, क्या उसका strict interpretation होना चाहिए, क्या उसका liberal interpretation होना चाहिए, या फिर उसमें golden rule लगाना चाहिए, right? So these are the terms that are being used in interpretation of statute, कि statute को कैसे interpret करके कैसे apply करना चाहिए. So यहाँ पे बोला गया है मेडिकल ट्रीटमेंट के रीइंबर्समेंट के जितने भी प्रोविजंस हैं उन सबको लिबरली कंस्ट्रक्ट करना चाहिए, ठीक है, स्ट्रिक्ट कंस्ट्रक्शन नहीं, लिबरल कंस्ट्रक्शन करना चाहिए उसका. नाउ देयर वाज अ छत्तीसगढ़ हाई कोर्ट बेंच दैट हैज हेल्ड दैट द सेल्फ प्रिजर्वेशन is the facet of the right to health, a fundamental right under Article 21 of the Constitution of India. And also they directed the authority to consider the request of the petitioner for post facto medical reimbursement. And Justice Sanjay Kumar Agarwal held that the provision related to the reimbursement of medical treatments to be constructed liberally. Okay, now also the court held that the right to health includes right to affordable treatment. It also includes the provision related to reimbursement of medical treatments to be constructed literally and liberally. ठीक है जी, liberally करना है तभी ये बोला गया है, right? Now coming to the next part, that is that the transfer of tenancy does not amount to creation of new tenancy. ठीक है, अगर आपका टेनेंसी ट्रांसफर हो रहा है तो उसका मतलब ये नहीं है कि वो नई टेनेंसी हो गई, ट्रांसफर हुआ है, सिर्फ नया क्रिएशन नहीं हुआ है. So there was a justice bench of Justice G.S. Patel and Justice Madhav J. Jamadar. We just read something from Madhav J. Jamadar. of the Bombay High Court observed that the transfer of the tenancy does not amount to creation of new tenancy. Okay, this is a random case I've just put up for your instance that you can look into it also. Now coming to the next part is that permitting the use of illegally intercepted conversation in the court would violate citizens fundamental rights. ठीक है जी, अगर भाई हमने किसी की ऑडियो रिकॉर्डिंग जो मैंने छुप के करवाई या करी और वो मैं जाके कोर्ट में सुना रहा हूं, तो क्या वो इलीगली इंटरसेप्टेड कॉन्वर्सेशन को कोर्ट मानेगा? नहीं. No, because it is violative of the fundamental rights, because fundamental rights is right to privacy, which is not covered here. Now the Delhi High Court has observed that such intercepted messages or audio conversations pursuant to made an order having no sanction of law are permitted. It would lead to manifest arbitrariness and would promote scant regard to the procedure and fundamental rights of the citizens. ठीक है जी, अगर कोर्ट ने बोल दिया कि हाँ हम ऐसी रिकॉर्डिंग्स लेते हैं, तो आप सोचिए कि सबके साथ क्या क्या हो सकता है, right? All your calls can be recorded. There can be a lot of backfire of that also, right? So that is why the court has made sure that doesn't happen, because it is against the fundamental rights of the person who is there. Right now there was Justice Chandradhari Singh, and who has set aside the two orders that was passed by the special judge, who had framed charges, one against one Jitendra Pal Singh in 2012 in a case registered by CBI on the basis of evidence gathered through such illegal means. ठीक है, तो ऐसे illegal means से CBI लेके आ गया उनके अगेंस्ट में कोई प्रूफ, तो ये सेट असाइड कर दिया गया जस्टिस चंद्रधारी सिंह के द्वारा. Right, so you can see that these kind of cases keep on happening. And obviously, if anything, or can you imagine if the court will pass a judgment in such a case and say that yes, it is admissible, तो सोचिए क्या क्या हो सकता है आपके साथ, आप सोच भी नहीं सकते, right? So this is the kind of small judgments that can change your life, and definitely they are very important to read also. Now some maxims, there is lex fori, that is like law of the forum where the case is being heard, right? So NCLT and CLAT, ये सब जगह पे जहाँ पे भी कोर्ट हो रहा है, सुप्रीम कोर्ट, हाई कोर्ट, जो तो लॉ है फोरम का जहाँ पे केस हो रहा है, दैट इज कॉल्ड लेक्स फोराई. ठीक है, नाउ कमिंग टू द नेक्स्ट पार्ट, दैट इज रिस्पोंडेंट सुपीरियर लेट द मास्टर आंसर. ठीक है, टॉट्स का अपने प्रिंसिपल बेसिक, लेट द मास्टर आंसर हियर. ओके, द नेक्स्ट इज वॉलंटी नॉट फिट इंजूरिया. Now an injury is not done to a person consenting to it. आप बॉक्सिंग मैच खेलने गए, आप खुद बॉक्सिंग करना चाहते हो, फिर आपके मुंह के ऊपर पंच पड़ा और आपके खून आ गया और टॉट असॉल्ट के लिए किसी को जाके सू कर देते, तो ऐसा नहीं हो सकता. वहां पे कोर्ट बोलेगा वॉलंटी नॉट फिट इंजूरिया, यू कंसेंटेड टू इट. अगर आप क्रिकेट मैच देखने जाते हो, आप स्टैंड्स में बैठे और बॉल ऊपर आपके लग जाती है आके, तो वॉलंटी नॉट फिट इंजूरिया. जब आपने टिकट खरीदी थी तो आप इस बात को कंसेंट कर रहे थे. बट अगर आप क्रिकेट मैच देख रहे थे और आपके ऊपर से छत गिर जाती है क्रिकेट स्टेडियम की, तो वॉलंटी नॉट फिट इंजूरिया नहीं अप्लाई होगा. क्यों? क्योंकि आपने उसके लिए साइन अप नहीं किया था. राइट, नाउ कमिंग टू द नेक्स्ट पार्ट is definitely make sure that you are liking the video and also subscribing to the channel, because that motivates all the mentors to make videos for you. So definitely that is something that you should all do. That is your responsibility as students to do. Hit on the like and the share, subscribe button, and don't forget to hit on the bell icon. And do take care of yourself. You know the COVID cases are increasing in the country, and this is the most important time for you guys, and every day matters here. So do take care of your health, stay safe, use your mask and hand sanitizers. Don't forget to wash your hands, and also maintain social distancing. And if you are above the age of 18 years, do get yourself vaccinated as soon as possible. Right, so take care guys. Thanks for joining this live session. Hope you all liked what we did today, and join the next video on Wednesday, the same time and same place, and we will be having a detailed conversation also, right? And I'll be having a small conversation about exam stress and the points and the techniques that you can use to control your anxiety during the exams, right? So that's it for today guys. Thanks for joining the live session. Take care of yourself, keep smiling, and keep preparing. This was your host Sanjeet Bhatia from Pratham Test Prep. Hope you all liked the video. Please don't forget to subscribe to our Telegram channel @ CLAT @ Pratham. Thank you guys. Bye bye. Take care.